Have you been getting nonstop calls and letters from collectors trying to collect debt you may not be actually able to pay? Well, or maybe the creditor turned the account over to a collection agency and now you're getting calls from them. Or your creditor or debt collection company that purchased the debt might try to pursue you in terms of legal action to try to collect on this debt. Well, if that's the case, you need to know how to deal with a potential default judgment. So that's what we're going to cover today, and let's get into it. Welcome to Ascend Finance's YouTube channel, where we cover debt relief and help you understand the costs, pros and cons to help you be more informed and get out of debt cheaper, easier, and faster. My name is Justin, and let's get into it. In this video, I'm actually going to cover how to handle a default judgment. Now, of course, this is not legal advice. It's just for information only. I'm going to go through a couple things here, and one is going to be what a default judgment actually is, and then 5 different ways to deal with a default judgment. Now, as we understand, everyone's situation is unique. We want to be able to provide something to help personalize it to you. And so we actually built a free debt resolution options calculator that I actually linked in the description below that'll provide cost, duration, and the pros and cons of your different options to help you understand what you may be able to do to resolve. Now, if you end up liking this video, feel free to click the like button below, as it's always encouraging for us to see. And as well, if you want to see more content like this that'll help you get out of the debt, feel free to subscribe as we try to make new videos weekly. So without further ado, let's get right into it. And so as the first thing I noted about, I'm going to kind of give you an idea of what a default judgment actually is. Now, if you can't repay a debt, the creditor may try to file a debt collection lawsuit against you. Now, a default judgment is a court order saying that you actually owe the debt to the creditor. So the creditor can take various actions to collect on the debt, which they may try to garnish your wages or maybe seize assets. But with that said, you do have options. And so that's why I want to go through next 5 different ways to deal with a default judgment. Now, ignoring a default judgment may be one of the worst ways to deal with it, as may actually lead to what I was talking about earlier, like a wage garnishment. Now, it does depend on the law in your state though. So the creditor could try to seize most of the funds in your bank account instead. So instead of trying to ignore it, maybe try one of the different ways to deal with it. Like this. One would be try to offer a lump sum payment. So if possible, offer to pay a lump sum to just pay off the default judgment. It could be a settlement for less, because some creditors actually may accept a lower amount to pay off the default judgment if you make a payment one time. So let's just say you owe $10K. And that they have a default judgment, they're coming after you for the $10,000. Well, the creditor might accept 70%, or in this case, it'd be $7,000 to satisfy the default judgment. But before making that lump sum payment, make sure you have an agreement in writing from the creditor showing that you're settling the account for less here. Now, it may be important to understand whether it makes sense for you to do that. And so I actually linked in the description below our calculator called Should You Settle Debt? And that'll help you understand whether it makes sense for you even to do that, or if it makes sense to maybe look at hiring an attorney to do that. But nevertheless, there are a few other ways to handle it if there is a judgment. And the second would be maybe to file a motion to set aside the judgment. Now, filing a motion with the court asking the judge to set aside the default judgment, there may be a reason why a judge might do that, which could be based on the lack of notice of the lawsuit or hearing, you weren't informed correctly, or your failure to file an answer was because of a mistake or accident instead of an intentional or conscious decision to the lawsuit. Now, you actually may file an answer to the lawsuit, but you're prevented from attending the hearing because of an emergency or some unavoidable situation. Any of those reasons could be something for them to potentially put it aside. Now, the third thing is actually paying the creditor. So I touched on earlier trying to settle, but you may be able to pay the creditor to satisfy it. Now, once the debt is paid, the creditor should file a satisfaction of judgment with the court. Now, some creditors could work with you to arrange a repayment plan. However, the creditor will not satisfy the judgment until it's actually been paid in full. With that said, the creditor is not obligated to accept payments for the debt. Fourth, you can claim assets and income potentially as exempt. If you cannot pay the default judgment, you may need to claim your assets and income as exempt to avoid the creditor from seizing any of your property. However, exemptions and wage garnishment laws are different from state to state. So therefore, this option may or may not work for you. It just depends on where you reside. Fifth, you could potentially look at filing for bankruptcy. Now, if you can't protect your income and assets or pay the default judgment, you may want to consider filing bankruptcy to deal with it. Most default judgments are discharged in a bankruptcy, which is basically looking for your forgiven. The debt is closed. It's forgiven. You do not owe it anymore. Now, many debtors complete a no asset Chapter 7 case in about 4 to 6 months. It's relatively quick. Therefore, you could get rid of the default judgment without making any payments. You can also get rid of any other unsecured debts you may have, like credit cards, medical bills, personal loans, payday loans. Default judgments are also discharged through a Chapter 13 as well, in many cases where you actually only pay, let's say, pennies on the dollar. So with that said, though, it may be helpful to understand whether bankruptcy is right for you. And so we actually built a Chapter 7 versus Chapter 13 bankruptcy calculator for you to understand what the difference is between the two, the pros and cons, the cost estimate, and whether you actually qualify for a Chapter 7 bankruptcy. If you have any questions at all, though, you can request to speak with one of us. We can go through your situation a little bit and help you understand whether you may be actually just able to settle with a creditor versus filing a bankruptcy. Now, I do clearly hope that this video was helpful, but if you do have any questions, feel free to comment down below, as I'm sure there are many others with a similar question, and we'll try to get back to you as soon as possible. Or if you want to speak with me directly or someone here, you can give us a call or text at 833-272-3631. Or if you just want to talk about your situation, I'm more than happy to chat. Thanks again for watching. I'm always here if you have any questions.